We have a quorum and we've passed the appointed hour. So let us start our meeting. May I welcome the government officials, and they are Madam Chen of PAS of the Transport and Housing Bureau, Mr. Jason Lam, Assistant Secretary, Transport, and Mr. S.F. Wong, General Manager, Shipping Industry and Seafarers, Marine Department, and Ms. Mabel Chang, Senior Government Counsel. They are here to answer your questions. In respect of Mr. Tang Ka-piu's letter, and also the views given by the deputations on 17th of June, the administration has given a reply, and the reply has been given to members, and the paper number is CB1-1396-1213-01. I just want to ask the administration whether it would like to highlight any major points. Thank you, Chairman. In fact, we have replied to Mr. Tang and also the deputations verbally, and we are just repeating ourselves in that written reply. Do members have any questions? No. Good. The legal advisor has also raised several questions, and the administration has given a reply. And the points are related to different clauses in sections. So we will we'll deal with that when we come to those points. So shall we go to clause by clause study of the bill? Please refer to the markup copy prepared by the Legislative Secretariat. Part 1, amendment to the introduction would yes, Chairman, yes, on page 1 on interpretation, we propose to cross out company roster because there is a replacement. This is the company roster. At present, only a company can do the recruitment and placement. But according to the demand of the unions, seafarers unions can also have a roster under the new bill. So we have the definition of roster as for the approved organization, approved crew department, we have the division. Yes, on page 2, we have we propose to cross out direct entrance. There is no direct entrance. All seafarers have to comply with certain requirements before they can be employed. And on page 3 of the Chinese version, concerning definition of seafarers, we propose to amend it, and we propose to put it under section 2A of the bill, which is on page 6 of the English version. If you may refer to 2A, according to the requirement of the MLC, seafarer means a person who works on board a ship in any capacity. And the signatories are allowed to consult the local organizations and seafarers organizations and shipowners associations, and can exclude certain persons by a list. So under 2A2, the Secretary for Transport and Housing may, after consulting the Advisory Board, by notice published in Gazette, amend Schedule 1A. And Schedule 1A listed those who are excluded, and they are on page 60. Okay, let us move on. Legal advisor. Now, with the definition of seafarer, in fact, our division has written to the administration, and this is paper 1284. Chairman, if we may refer to the markup copy, which is page 6 of the Chinese version, and also page 6 of the English version. If members may refer to the new definition. This is capital to capital A. Seafarer means a person who works on board a ship in any capacity, but does not include a person specified in Schedule 1A.
Board a ship in any capacity, but does not include a person specified in Schedule 1, capital A.
Chairman, we can see that the new definition of seafarer is very broad. It means anyone who works on board. And there may be a chance or possibility in which a customer may employ somebody to accompany him to work on board. Say but the person is immobile, who has employed a nurse to accompany him or her, or the tourist guide who work on board. The person is working on board, but their work has nothing to do with the operation of the ship. Therefore, according to this definition, these people may be included in the definition of seafarer. And if you look at the Chinese version, the problem may not be so obvious. It means anyone who holds a position on board and works in that position. But this is the English version is who works on board in any capacity. Members may also refer to Schedule 1A together, and that is page 61 of the English version. Schedule 1A, as said by the PAS, it refers to those who are not included under Section 2, capital A. This is a provision to exclude certain persons. Say, for example, 1E, an officer of a law enforcement agency who carries out law enforcement duties on board the ship. Chairman, our understanding is that if you want to exclude certain persons in a definition, then if one is not included in Schedule 1A, then one is included in the definition. Say for 1E, an officer of a law enforcement agency, say for example a Marine Department officer or a Customs and Excise officer goes on board and conducts law enforcement on duty on board, and then he may fall within the definition of capital to capital A. So these persons are to be excluded under Schedule 1A. By the same token, that will have the implication I mentioned earlier. Say, for example, somebody who has no relation with the daily operation with the ship, but the person works on board for one reason or another, and that person, therefore, may be included in the definition of seafarer. So will the administration consider doing another exclusion? Say, for example, the person works on board, but the person's work has no relation with the daily operation of the ship. So I think that is something all-embracing, so-called all-embracing arrangement. Mr. Sin Chung Kai, yes, I'm following up on this. I'm following this. In fact, there will be many cruisers coming to Hong Kong, and say there may be waiters, waitresses, and also dancers, singers on board. Are they seafarers at all? In the mind of the administration, that's the point I want to raise. They are not passengers. they are not passengers. They are not employed by passengers to care for passengers. They may be employed by the crews on contractors. There may be many contractors. Say, for example, they just come to play magic on board, and then after playing magic on board, then he or she may depart immediately at the next port.
I'd like the administration to respond. We wait until all members have asked questions. Well, this is not unique to Hong Kong, so there are two types of people: those who really work on the ship but not employed by the ship owner to provide medical services or to provide entertainment, and also employees brought onto the ship by passengers. I don't know whether there is a third type. Administration, please respond. Well, the drafting of 2A, Section 2A, has made reference to the wording in the MLC. I think the interpretation of seafarer should follow the common sense approach that is not to cover anyone that has nothing to do with the operation of the ship, such as waiters and waitresses and dancers. They are not seafarers. According to Cap 478, seafarers have to be registered with the Marine Department and to fulfill certain requirements before they are fit to work under the direction of the sea captain. So those referred to by members should not be seafarers. So that's our proposed drafting. Our lawyer from the DOJ, any supplement, please? Thank you. The legal advisor raised a point that is on the definition of seafarers. Well, we have made reference to the drafting of the convention, so the coverage may be rather broad. People who work on the ship but not related to the operation of the ship. For instance, a passenger who has employed a nurse to look after him. While the nurse is working on the ship, will he or she fall under the definition of seafarer? Well, as the PS said, we must construe the meaning in the context. All right, when we talked about a seafarer, he must be engaged on board a ship to deal with the operation or running of the ship. So a private nurse employed by a passenger is in fact a passenger. She has nothing to do with the operation of the ship. We believe this is very clear. There won't be any ambiguity. And a member talked about various types of workers on board a ship. In fact, in Schedule 1A, we have excluded some categories of persons, and the definition applied to ships registered in Hong Kong, because all ships are regulated by their flag-flying country. We do not rule the possibility that in other places the definition of seafarer would will not cover people excluded in Schedule 1A. So Cap 478 would only regulate ships registered in Hong Kong. Ms. Sitho, I beg to differ from the administration's point of view that we should understand the definition by looking at the context. What is there to prevent the definition from being clearly spelled out here? In the past, when we legislate locally on international conventions, we made known the view that we should not just copy directly from this convention. We should include the convention in our schedule. If we just copy all the provisions into our local legislation, then this situation will arise. If we rely on the context to understand the meaning, why can't we instead have the definition clearly spelled out, so that in future people who refer to the bill will know who are seafarers and who are not. Chairman, our bills are drafted in a very bad manner recently. We have to understand the definition clearly so that people know who are protected under the legislation. Anyone from the administration? Thank you, Ms. Ho, for your question or your view. When we construe the meaning of definition, we usually consider the context. We will see whether this definition can be made even clearer. Usually, or actually every time, we will consider the provision very carefully. We don't just copy from the convention. I'll discuss with the Bureau again. Well, the convention applies to more than 100 countries, and the situation may differ from countries to countries, and usually the convention represents the lowest common factor, the minimum common factor in signing the convention. While the convention provides the principle, the broad principle, we have to make our local legislation clear to reflect our local circumstances. Any response from the legal advisor? The administration submitted that in interpreting the law, the context should be considered, and that the usual understanding of a seafarer would not cover persons mentioned by Mr. Sin Chung Kai. But please refer to the marked up copy, page 61. Schedule 1A. Well, the usual interpretation is, well, if you want to include somebody, if they are not excluded, that means they are covered. So what about law enforcement officers? Using the government's position, law enforcement officers are on board a ship to enforce the law. They have nothing to do with the direct operation of the ship. Well, using the administration's understanding, now if they are not excluded, then perhaps they will not be covered in the definition as well. Well, to understand what is included, we may have to refer to Schedule 1A, where persons are not included are spelled out. If we exclude specified groups of persons, and if you do not put it clear enough, these people may fall under your definition of a seafarer. To play safe, I think we may follow Ms. Ho's view. If the policy intent can be clearly reflected, and we spell out in the provisions, people that are covered and those that are not included may provide clarity. Schedule 1A1G. The administration may consider the following. We're talking about people who are related to the construction, alterations, and so forth of the work. And paragraph 2 of G says, a person whose work does not in any way relate to the normal operation of the ship within its deck, engine room, or catering department. So perhaps there should be a paragraph H to say that any persons who work on the ship, on board a ship, but if their work is not related to the operation of the ship, they will not be included. From my understanding of the government's policy intent, they are not included in the definition anyway. So can the administration consider a similar something of this kind to enhance the clarity? Mr. Sin Chung Kai. Well, forgive me, I'm long-winded. I think I made this point previously. In international cruises, there are people who do not fall under 1A to G. They are not the owner of the ship. They are not law enforcement officers. They do not work in the port. Rather, they work on board a ship. There can be many such persons. Even if you disregard the waiters and waitresses, they might be contractors who teach the kids rock climbing, and some physical fitness trainer, massager, chef, so on and so forth. You have to consider these persons carefully. I don't know whether international cruisers regard them as seafarers and whether they are covered. Well, if you regard them as seafarers, it's okay. But please tell us the international practice. They are very common in cruises. Because for large cruises, they may have a tonnage of over 100,000. Well, Mr. Wong, you claimed that you were once a seafarer. I think you were related in the operation of the ship. But what about bartender? They're just there to prepare cocktails and drinks. So you have to consider and tell us whether it is international practice to cover them or not. Ms. Sit-ho, I'd like to seek some information papers from the administration. When international conventions are put in place in Hong Kong by domestic legislation, what is the government's latest treatment? In the past, the conventions were annexed in the local legislation. Sometimes you just selectively include some of the provisions. And there were also cases where there's a redraft, a rewrite by the administration. You must tell us your principle. You should not do it differently each time. So can we have a paper from the DOJ to tell us how the administration, what is the current and future policy of the administration in enacting local legislation to reflect international conventions? Mr. Tang Ka-piu. When we discussed with trade unions, we were told that of all seafarers who work on board ocean-going vessels will have a so-called red book. So for those who are engaged in different tasks on board a ship, do they have this so-called red book? Is it a useful tool or identity, proof of identity for their protection? What if a person who provides entertainment on board a ship complains to the Marine Department that they are not given 18 they're not entitled that 8 hours of work per day. Instead, they are asked to work for 18 hours. What will you do? And there are also people who say sell mobile phones or pictures, or who sell paintings and pictures on board a ship. And what about tour guides, tour group leaders, and what is their status? Administration. Thank you, Mr. Xin, for your views. We will reconsider the definition once again to see whether other trades who are not seafarers are covered. Now, we do not have any registered cruise ships in Hong Kong. Well, we don't know the possibility because of the commissioning of the cruise terminal. We will revisit the definition of seafarer to consider its clarity. Now, a piece of information for your reference, because I was a seafarer for a long time. There's a gray area. There might be a representative of a ship owner, and he may live on board a ship for a while to manage some business, and he is not regarded as a seafarer. And there are people who have to maintain a ship, they are mechanics and they have to stay with the ship for a while, and they're not regarded as seafarers while they are really working on board a ship to repair the engine, for example, and they're not seafarers. And what about medical doctors? Some are regarded as seafarers, some not. So how do we define it in the trade? Now, in the captain, there is an employment contract. We have to sign a payroll slip every month. If we're required to sign to certify receipt of our pay, then we are regarded as seafarers. And then in Hong Kong, there is a service record booklet for each seafarer. We call it the Red Book. If you have that Red Book, you are a registered seafarer. And there are people who go on board a ship without that Red Book. He carries a passport for seafarers. We call that an international book, and he is not regarded as a seafarer. So the situation is rather complex. I hope you can think twice, because after all, this is legislation, and this is very different from just talk about the concepts.
Thank you, Chairman, for your view. We'll go back and think about it. Now, concerning this bill, it is related to the registration of ships. Now, if a cruise ship has come to Hong Kong, and then there is a labor dispute, and then the matter is brought before the court, will that call this invoke this piece of ordinance? Well, it is about the benefits and protection of seafarers. If that definition is not clear, there will be a lot of disputes. I hope the administration should better clear up this. Thank you very much for your view. That's very correct and very insightful. I know that there is a seaman's passport or seaman's identity card, and in fact in the past there was seaman training provided by the Polytechnic, and there is also the sailors training school in Hong Kong, and you need to have this certificate or ID card in order to seafarer's ID card in order to be a seaman. And this is in the local law. This is to protect certain persons and impose certain legal liabilities on certain persons. Now, different countries have different definitions. And suppose in Hong Kong waters a certain litigation happens, and if our law is not clear, then it will be really troublesome. We really urge the administration to move a suitable CSA. We urge the administration to clarify this definition. The administration. Oh yes. We'll go back and think about it and see how if we can tidy that up. Okay, let's move on if you don't have further questions. Yes, please move on. Yes. Let us go back to the markup copy of page 3 of the Chinese version. We've gone over the seafarer definition, and we propose to cancel the definition of able-bodied seaman, because that has already been included in the definition of seafarer, and we don't need an additional one. And that is the permitted crew department, which is amended. Not only a company can recruit and place a seaman. So we will have permitted. We will have permitted company and also permitted crew department. And we also change the reference from company to organization. And in the reference to organization. And apart from a company, a seafarers organization can also apply for a permit. So we will include seafarers organization as well. As for registered address, we change a registered seafarer to registered person. According to the MLC, a seafarer refers to somebody who is employed to work on board, but the registered person may have to be employed only. He is may be waiting for employment only. So we will make changes accordingly. Registered seafarer will be changed to registered person accordingly. And we change the definition of registered seafarer to registered person by the same token. On page 5, the definition of employer is also amended in line with the MLC. Employer in relation to a seafarer employed to work on board a ship means the person identified by name or necessary implication as employer of the seafarer in the following agreement entered into by the seafarer for work on board the ship. If the we have crossed out A1 of the original definition, and we also cross out capital A and capital B. Here it refers to owns, charters, or manages, or acts as an agent for another person who owns, charters, or manages that ship. These no longer exist, and therefore we cross them out. Okay, if there is no question. Next is the employment registration book. We changed registered seafarers into persons. And as for seagoing ship, we just tidy up that part because we use that term. And then page 6 of the markup copy, I have already explained that in terms of the amendment to 2A. We'll go back and look into that. And then page 6, the establishment of the page 7 rather, establishment of Seafarers Advisory Board. There is an amendment. The STH may amend Schedule 1A. So in amending the definition of seafarer, there is a need to expand this function of the advisory board to advise the authority on matters which is related to the definition, i.e. those to be excluded. And then page 8, part 3, Register of Seafarers. We improve that to Register of Persons Employed as Seafarers and of Persons Desirous to be Employed as Seafarers. And then the following amendments are textual. Reference to seafarers will be changed to persons because we want to include those persons who desired to be employed as seafarers. We propose to cross out 7.5. The provision has been changed. The definition of seafarer has been changed, and this one, 7.5 no longer applies, so we need to delete that. Page 9, 8.2b, we cross out the maximum age for for becoming seafarers, but the person has to. We retain the age of 17 as for minimum age for becoming seafarers. And then we propose to add 2.5. No, my apologies. 2D Roman small Roman 4. which refers to a certificate of qualification as a ship's cook, he is included as a seafarer. That's according to the MLC. And then 8.3, the reference to seafarers is changed to persons. Yes, please go on. And then page 10 is still section 8, reference to seafarers will be changed to reference to peasants. And then section 9, we cross out 2B, but has not attained the age. We maintain the minimum age of 17 for becoming a seafarer. Page 11, we cross out section 11 because we've amended the definition of seafarer. This one no longer applies. 12, section 12, we changed the wording so as to make it in line with existing drafting style. But we've made a mistake. 12.2a should be, or rather, there is a mistake concerning section 15.3, and we will amend it. Page 12. Like the previous ones, reference to seafarer changed to person. Section 14, we cross out rating and replace it by rank. Rating only refers to ordinary seamen, but rank includes senior seamen and all those who work on board, be they junior or senior. Page 13. Amendments to section 16 is also the reference of seafarer changed to person. Same for section 17. And then page 14, the title is amended to make the reading clearer, and there is no change in meaning. Page 15. Section 21 is a textual amendment. It doesn't affect the operation of that provision. Okay. And also for amendments, section 21, reference to seafarer is changed to person. Page 16. Also, the amendments to section 21, reference to seafarer changed to person. And then under 3B, without delay instead of replaces forthwith. That's our present-day practice. Page 17, a change to section 25. Seafarer changed to person. Go on, please go on. Page 18. Amendments to section 27. Seafarer changed to person. And we also propose to amend 27.2. This is a textual amendment to make it in line with our present-day style. It has nothing to do with this effect and operation. Section 28, same, seafarer changed to person. Legal advisor. I think a legal advisor wants to say something. On section 28, we have a drafting issue. In fact, we wrote to the administration last week, and it's paper 1412. Bracket 01. We've sent the paper to the administration and members. This is a drafting point. which is shall replaced by must. Members, or rather the Bills Committee has taken note that in the new style of drafting, shall is replaced by must. If you look at the markup copy, page 40, which is to amend section 64, and you can see that shall is replaced by must, and under subclause or subsection 3, shall is also replaced by must. That happens many times in this bill. But as I've highlighted in my table in the letter, I have found that the administration does not change other shalls into musts. I think my understanding is that in all the new laws, shall will be in all the new laws they will use must. But if it is an amendment to, if it is an amendment, then it depends on the situation. And if there is no amendment of shall into must in a provision, or rather, if there is no amendment to a particular provision, then the shall will not be changed to must. But if there is an amendment to that provision, then if there is a word shall, it will be replaced by must. If you look at markup copy page 19, on the left-hand side, you can see the original ordinance, and then on the left-hand side, on the right-hand side, the amendment. If you look at subsection 4, the administration proposes to cross out forthwith, serve on. And before forthwith, there is the word shall. Why can't the administration amend this shall as well? Now, since this provision is to be amended, why can't the administration also amend this? Just cross out one more word. That's for the administration and for members' consideration. On the table, there are many other provisions which have the word shall or forthwith, and they are not going to amend that. Yes, the administration. Thank you, Chairman, and thank you, Legal Advisor, for the question. I also thank the Legal Advisor for looking into such details. Let me explain the amendment of shalls. The Legal Advisor has pointed out the reason. Now, the Cap 478 was enacted in 1998, and the drafting style has changed a lot. Now, in the new laws, we use must rather than shall, and the meaning is the same. When the meaning is the same. In amending the ordinance, we have, or in an amendment bill, we have many factors to consider. There are archaic words such as forthwith or shall. They appear in many provisions of Cap 498. That is a theme of this amendment bill, and that is to implement the MLC. Whenever possible, we will modernize the provisions. But we don't want that kind of technical amendments to be so excessive that it has taken the limelight from the theme of complying with the MLC. As said by the Legal Advisor, if there is any substantive amendment to a particular provision, then we'll change the shall into must or forthwith into without delay. But it depends on the actual requirement of the MLC.
So when deciding how far should we amend, should we go? How far should we go in these technical amendments? Should we only amend them when the two terms are very close, just one line apart, two lines apart? Well, there is no scientific judgment for this. So if we see fit, we will amend it. We don't want members to spend too much time in vetting very technical amendments related to shall or must if the amendments are just textual in nature, such as changing from registered seafarer to a registered person. We'll use a simpler way of doing it. We do it by means of a schedule. Well, if that's the case, we will certainly not deal with things like shall or must. So there may be inconsistencies. As pointed out by the legal advisor, well, even though the two words are very close to or just in next to one another, we haven't changed the words because the purpose of the amendment is to implement the convention. So there are still a lot of words such as shall and must, while their legal meaning is exactly the same. That being the case, CSAs will focus on substantive amendments. For instance, amendments to the definition of seafarers. But that will be the focus of our CSAs. Thank you. Legal advisor. Of course, I fully understand the administration's policy and also their general position in the use of words such as shall and must. Well, Chairman, you see, I'm not asking the administration to change or to replace all shall with must in Cap 478. It's just that in different places now, if there are already amendments to a certain provision, why doesn't the administration take the opportunity to replace shall with must as well? And a marked up copy, page 20. On the right-hand side, there is new subsections 2 and 3. They are rewritten. Well, in the new subclauses, shall has been replaced with must, whereas in 3.1 we still see the word shall. The DOJ Law Drafting Division has got a guideline on, it's actually a code of practice on drafting of legislation. Para 9.2.18 is on the use of shall or must. Well, for the sake of consistency, if shall or must is used instead of shall, then all other shalls should be replaced by musts. So, according to this code, if just very near must is already used and yet shall appears there, then they may not contribute to consistency and may not be too desirable. And if members may refer to page 40 of the marked up copy, amending section 64. On the right-hand side, there is a total rewrite of section 60, and in subsection 1, the word must is used, and yet in subsection 3, the word shall is replaced by must. The administration has taken this opportunity to replace shall with must here. So, in such a case, the administration would replace shall with must in a relevant place. There are about 10 provisions where the word shall is not replaced by must in similar circumstances. I'm not asking for the whole ordinance to be amended, but if just very near a particular provision there is already an amendment, why shouldn't the administration take the opportunity to tidy up the text as well? Administration. Any response? Thank you, Chairman. So it said that in different subsections we have must, and in other subsections we have shall. Yes, we have noted that as well. The legal advisor mentioned our guide for law drafting. We may not be able to amend everything in an ordinance. We're saying that so long as there is not the old and new styles appearing in the same subsection, it is acceptable. It is allowed. Of course, that's not the most desirable, but when an amendment is made, there are other considerations. So this is allowed under the code or guideline. So what we do here is in line with our guideline. The administration or the legal advisor said that some provisions are mentioned in his letter to us. Yes, we have read that letter. Now we are doing a clause-by-clause scrutiny of the bill. We like to focus at the content of the provisions. As we go on, other amendments might be needed, and when we do so, we may deal with issues raised by the legal advisor at the same time. So let's continue with the clause-by-clause scrutiny. And afterwards, we will consider how many CSAs are involved, and we'll discuss with the Bureau and whether technical amendments involving shall and must should be included as well. That's my proposal for the time being. Any views from members? Ms. Ho. I apologize. I was out of the room to answer an important call. Well, the administration is in the process of modernizing its laws. Now, in the same ordinance, I think there should be consistency in terminology. Now, when there are amendments, well, as far as possible, you should modernize your terms. And we understand that it takes time for you to adapt your laws. But since you're dealing with this ordinance, I hope the government will not be that lazy. You should do it in one go. Otherwise, it will be like a law adaptation. We haven't completed the whole exercise in more than a decade. Because when people read the law, they will have a big question mark. Why are different words used? Do they have different meanings? Of course, people from the legal sector will understand this is just the same. But if you have two ways of drafting in the same legislation, you would confuse people. And a good piece of law should be comprehensible to a layman. After all, the law is not just for lawyers. So I would like the administration to tidy up the legislation here. Will you consider the legal advisor's view? Yes, we will certainly do so. Then can we go on, please? Page 19. Amendment to Section 29. Again, a reference to seafarers would mean a person would be replaced with persons or person. And subsection 3 will be the usual way of presentation. Marked up copy, page 20. Proposed amendment to section 29 will be very similar to previous amendments. References to seafarers will be replaced by persons, and also use without delay to replace at once or forthwith. And again, references to seafarers will be replaced by the word person or persons. Okay, please go on. Page 22 of the marked up copy. proposed amendments to Section 32, just similar to previous proposals, to replace a seafarer with a person, and also forthwith replaced by without delay. Page 23, amendment to Section 34, to replace a seafarer with person. Next. Page 25, proposed amendment to Section 37, seafarer replaced by person, and we've also amended subsections 2 and 3, textual in nature, to make it clearer without any change to the content or meaning. Page 26. Amendment to Section 39, a textual amendment again. Change in presentation, but no change in meaning. Next, page 27. Amendment to Section 42, to replace a seafarer with person, and to replace a company with organization or permitted bodies, to include seafarers' organizations. Page 28. To amend Section 44, seafarers replaced by persons, and also companies replaced by bodies. We've also proposed to amend Section 3.
The prescribed fees in the past, it was allowed to obtain no more than half of the fee for recruiting the seafarer. But now it is to be paid by the approved organization or permitted organization rather than by the seafarer. Amendments to Section 45 also replaces seafarer with person, and then company with organization, and then forthwith replaced by without delay. Same for the rest of Section 25. Page 30. Amendments to Section 47 mainly deal with reference to seafarers replaced by person. Page 31. Same. Seafarer replaced by persons. Person. Page 32. Amendments to Section 55. We've added the following. Or rather, we amend 52(1)(a). We've added A2. Say if a seafarers organization is to do recruitment and placement and supply, and then the seafarers organization must have that in the memorandum of association or constitution of the organization. And we change company into organization. Amendments to Section 53 include 1B. The company applying for permit is changed to the applicant. Those who apply for a permit may not, one who applies for a permit may not be a company. So it is an applicant. Page 33, amendments to Section 54. The company is replaced by applicant, and reference to seafarer becomes person. And we've added 54(1)(d)(5). It is in line with the MLC. The Seafarers organization must set up an insurance arrangement, whether by way of insurance or otherwise, to ensure that any registered person to be supplied by the crew department will be fully compensated for any monetary loss. If there is no such insurance, then the permit may be revoked or withdrawn. Page 54, or 34 rather, continues the amendments to section 54. We propose to cross out subsection F. F refers to section 57. We're going to amend this. 57(1). We're going to amend it. There is no agency for recruiting seafarers. All the recruitment is done by the company, so we don't have any need for 57(1). Okay. As for amendments to subsections A and B, change from company to organization. Page 35. Amendments to 55. Company becomes applicant. And amendments to 56. Reference to company becomes body. And then 56(1)(c), the company becomes person. 56(1)(c) Roman 2 and 3. Page 36. We propose to add subsection G. This is to comply with the MLC. When a complaint is received, then an investigation has to be made, and then the outstanding complaint has to be reported to the authority. If the applicant is not able to observe that, if the permitted organization is not able to comply with that, the Marine Department may revoke the permit, and we change the reference to company with organization. Amendments to 57 includes the following. It refers to those who can work on board, the registered persons that can work on board. With cross out 57(1), the kind of agency business. Now, if the permitted organization is a company, then the registered person can only work on the ship that is owned, chartered, or managed by the company. We don't allow any agency service. We also cross out 2AB. 2A and 2B have been included in 54(d), so we don't need to repeat the provision. Page 37. Section amendments to 58. Company replaced by body. And forthwith is replaced by no more without delay. Page 38. The amendment to section 60. We cross out reference to 57, section 57(1). It no longer applies. So under the new 60, there is no reference to section 57(1). Other amendments are just amendments to the style. Page 39, section 61. Reference to company becomes body, reference to seafarer becomes person, forthwith becomes without delay. Others are also textual amendments. Section 40. amendments to 64. Now, 64 provides for the arrangement of permitted crew department or rather the permitted persons who are on board. And reference to 57.1 is also crossed out. 57.1 57 has been amended, so 57.1 no longer exists. As for page 41, amendment to 65, section 65, reference to company replaced with body and seafarer with person. There are other similar amendments. Amendment to section 61, or rather 67, we cross out reference to 57 because there is no more agency service in terms of recruitment of seafarers. Section 68, the amendment also includes reference to company replaced by body and persons, seafarers by person. And we also cross out 61, rather 68.2, reference to section 57.1. Page 43, the amendment to section 68 continues. Seafarer replaced with persons, and then company replaced with body. Page 44, amendments to section 70. We cross out 1B's reference to section 57.1. There are textual amendments as well. Seafarer replaced with person, or seafarers replaced with persons. Section 45, or rather, page 45, amendments to the amendments to section 79. This is about discharged seafarers. Now, if a discharged seafarer, except with the permission of the master of the ship, no seafarer is permitted to stay on board. And since definition of seafarer includes the master of the ship, we have to amend. We have to add 1A. If the one dismissed is a master, the master of the ship, he can remain on board if he is permitted by the employer. I want to ask a question which may seem to be foolish. How are you going to solve the problem if he remains on board? If he's at the port, then he can be repatriated to the home port. But if he is on the in the voyage, he has to remain on board. You can't throw him into the sea. Yeah, I'm not in the trade, so I have this question. Now, if he is dismissed lawfully, then he can do that. He can suffer that at any time. Lawfully discharged. That can happen at any time. Now, if you make a serious mistake, or if you are suspected of damaging the ship, then you will be prevented from having access to any engine or equipment or apparatus on board. You'll be taken away from your post, and then when you reach a port, you will be sent back to your home port. Maybe the Marine Department can comment. Yes, that's similar to the point raised by the chairman. Let me answer the question. If the person is discharged during a voyage, that did happen. Now, say, for example, there was a murder on board. The master will lock that person up in a cabin, and then he will be checked from time to time. He'll be supplied, he's checked from time to time, he's supplied with meals. As said by the chairman, he's not thrown into the sea during the voyage, but on the next port of call, there will be disciplinary forces coming on board to take him away. If it is not serious, usually the seaman knows that at the next port of call there will be a representative of the company or the charterer who will send him home. If it is not a serious crime, even if one is to be discharged, we usually do not tell him that he will be discharged. He is discharged on the voyage. Usually, it is at the next port of call he is informed, and he's asked to leave. We're afraid that something untoward may happen on voyage. Please go on. Page 46. These are amendments to Section 80. We are to comply with the MLC. A seafarer must have a written agreement signed between the seafarer and the shipowner or representative shipowner. Amendment to 80. We don't have continuous agreement under 81A, and we also prohibit any agreement that cannot comply with the minimum standards of the MLC. Page 47. The amendment is to the title. We add on discharge. This is to reflect the content of Section 84.
Page 48. Amendment to the title, wages for seafarers to be discharged, so as to tally with the content of Section 85 in subsection 1. We have added that regulations can be made under Section 96. Because for wages-related regulations, Section 90, we will have subsidiary legislation made under Section 96, and we will submit the sublect to LegCo for scrutiny later. So, amendment to subsection 1. Under the new or the amended ordinance, seafarers would cover the captain or the master. If the master is dismissed, then the account of wages will be delivered to the seafarer. 49, page 49, amending Section 88, we propose to remove the reference to the master of a Hong Kong ship because seafarer would cover the master under the current or under the new definition. Amendment to Section 89. Under the convention, all wages of a seafarer can be allocated to a designated person. So, we have amended this subsection 1 to add all or a part of the wages. Page 50. To amend Section 90. Just as the previous amendment, a member or a family member of the seafarer has the right to claim all or part of the wages. Page 51, to amend Section 92, because a seafarer would cover the master. So in Section 91, subsection 1, we have required that the seafarer's employer may deliver the certificate of discharge to the seafarer. And for 94, because we have already covered the master in the definition of a seafarer, so we do not need separate provisions for the master. Page 52. amendment to Section 97. We propose to delete subsection 6 because in the subleg we will specify the penalties. Page 53. Amendment to Section 98, subsection 1. Where 3 or more seafarers feel that the water or food is of bad quality, they may make a complaint to the master. We have changed it to set the minimum at 1. If one seafarer can also make the complaint. And subsection 2. The seafarer can complain directly to the superintendent. No need to go through the master. And we've also added subsection 5. Seafarer can still make use of the complaint mechanism on board a ship to deal with the complaints. Page 54. To amend Section 99, subsection 1. Seafarer may make complaints in relation to anything relating to his employment on board the ship. This will widen the scope of complaint. Subsection 2 will allow we have new subsection 5. While the seafarer may complain directly to the superintendent, this does not affect his right to use the complaint mechanisms on board a ship for handling complaints. Subsection page 55, the penalties will be set out in the subsidiary legislation. Or rather, that was page 54. Page 55, to amend Section 102, we will add subsection 2. The owner has to be responsible for the medical care in respect of any sickness or injury suffered by the seafarer in the course of or arising from the seafarer's employment, and will set out the details in the subsidiary legislation. Page 56. Amendment to Section 104, repatriation of seafarers. Amendment to subsection 1. The original text is a seafarer may be repatriated under circumstances because of amendment to the convention will set out the conditions in the subleg. A and B will have the details laid down in the subsidiary legislation. So this will specify the mode of repatriation, and it will be found, details will be found in the subsidiary legislation. Page 57, amendment to Section 105. Again, we propose to specify the details in the subsidiary legislation, and so 105 is deleted. Section 106, consequential to the amendment to Section 104, will amend Section 106. Subsections 1 and 2 will be amended. The fees will have to fulfill the requirements set out in the regulations made under Section 104. If the related fees already paid, then the ship can be held until the ship owner has paid in full the fees incurred by the government. I'd like to ask about the operation of the trade. According to the administration, or in case of a serious crime, the master has the right to detain the seafarer in question. I understand that the seafarers or the ship is subject to the laws of the place where the ship is registered. If the seafarer is a Hong Kong resident and he has committed a serious crime, so in the next, when the ship calls at the next port, to whom or to what government will the person be handed to? Will he be handed over to the place where the ship was registered? And can the person request extradition? And whom can he turn to ask for help? Administration. All right, I will give a general response to Ms. Sitho's question. Ship owner and the P&I club concerned has a commercial arrangement. If, as mentioned by Ms. Sitho, a seafarer had an incident and he had been detained by the master, and he had to be repatriated, or if there was a shipwreck, the P&I club would have a legal team to provide advice and action. That is to advise the ship owner as to how the situation should be handled. Assuming that the seafarer is a Hong Kong resident and he has been repatriated to Hong Kong, and the current legislation empowers the authority to conduct a disciplinary hearing. Yes, I am concerned about the seafarer's right to legal representation. I'd like to know whether this P&I club will provide legal services to the seafarer in question, because you only refer to the expenses, recovery of expenses, and also relief. If he is involved in a crime, then he needs financial resources to acquire legal advice or legal services. Now, I can quote an example not involving a Hong Kong resident, but seafarers working on board a Hong Kong flag-flying ship, and then a seafarer there committed an offense. He was arrested by the law enforcement agency there for a trial. Our usual arrangement is, when we are aware of such a case, we will inform the Hong Kong police. Whether the Hong Kong police will consider sending a man to that jurisdiction, it is for the police to decide. It's up to the Hong Kong police. So I'm just quoting a known case in the past to you. Now, if the person who committed the offense is a Hong Kong resident, because your case involved a non-Hong Kong resident, I can't be 100% sure, but if a seafarer has committed a crime on board a ship and the ship has called at a certain port, and there, if he's arrested by the local enforcement agency, then whether he is a Hong Kong permanent resident makes no distinction. The jurisdiction there will follow their own legal proceedings. Now, if he wants to seek legal assistance, what can he do? Because he's detained, he cannot ask for help from the Consul General there. Well, he has every right to seek assistance. For instance, there was a case, a seafarer ran into trouble outside Hong Kong, and if we are made aware of that, we will inform the foreign ministry there. No. If we are aware that a seafarer working on board a Hong Kong ship, whether he is a Hong Kong permanent resident or not, if he has trouble in Hong Kong, we will approach the foreign ministry office in Hong Kong. And then the foreign ministry office in Hong Kong will then approach our consulate there. Will you inform family members of the seafarer? Will you inform the family? Will the ship owner inform the family of the seafarer in Hong Kong? Now, if the seafarer has run into trouble or has an incident, I dare not say whether there is any statutory requirement for the ship owner to inform his family, but as a usual practice, I think the ship owner will. Now, I am a layman here. I don't know whether local or overseas legislation can ensure that the Hong Kong permanent residents who is suspected of committed a crime will ensure that his rights be protected. Even if he is a suspect, he has the right to communicate with his family members. Now, if just in case the port is at a place worse than a third world country, then it's the ship owner's responsibility to inform his family members in Hong Kong so that they can launch a rescue action or whatnot. We want to ensure that a seafarer who is a local, who is a permanent resident of Hong Kong, will not be stranded in a place where the rule of law is very backward.
Now, if a seaman has committed a serious crime either on board or at the port, if he committed certain crime at the port, and then of course he would be handled at the port, i.e. in United States, in Europe, he would be dealt with by the law there. But if something happened on board in the high seas, then the the seaman will be locked up, and when the ship arrives at the first port of call, then the suspect will be handed over to the local law enforcement agency. The person will either be locked up in that port or will be locked up on board. Usually, the company will inform the family of that seaman. The family usually goes after the company if the seaman is, say, locked up or is or his whereabouts is not known. I think the unions play a very important role. Now, seafarers' unions have international connections. Overseas seamen who got into trouble in Hong Kong will be made known to the the Hong Kong seafarers unions, and we will follow the matter up. The service in the seafarers union of the seafarers unions of the European countries or North America will be even better. But when you talk about the third world countries, that's another story. Usually, we work through the authorities of we work through the ambassador, the consulate, consular offices, or embassies. Now, concerning the I think somewhere in the law and certain agreements, you need to put down this provision, which is the ship owner has the responsibility to inform the family members if the seaman is in trouble. Now, generally, they will do that, because if they don't do that, then they will be in trouble too. Well, the administration, as said by the chairman, yes, they will tell the family members, but we'll talk to the Ship Owners Association. We'll make sure that there is no doubt about it. Yes, Marine Department. No. Thank you. Okay, let's move on. Page 58 of the markup copy, the amendments to clause section 127. They are textual amendments. Under any person, if it supplies in any particulars or information. Page 59, concerning the regulations, we propose to add 3A. This is an empowering provision. We've discussed that with members before. The provision enables us to make direct reference to the provision of the relevant international agreement, so that that agreement can be applicable to Hong Kong. This is an empowering provision. If we are to invoke this provision, we will come before this council. Just a minute, legal advisor. Concerning, Mr. Chairman, concerning this new 3 capital A, with regard to this, many members have given their views. From a drafting point of view, we have written to the administration. This is in paper 1284. The drafting is a bit different from existing provisions in other ordinances. This direct reference approach is in respect of the merchant shipping related ordinances. And in those ordinances, the provisions do mention the relevant conventions. This is an inclusive approach. Say this applies to the conventions that are applicable to Hong Kong, including blah 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 what international convention. But we are not able to see the name of the convention here. So why is it? Why is there a difference? Thank you. Now the legal advisor has raised this question. In fact, we made reference to Cap 369 and Cap 413. In these empowering provisions, they do make reference to certain international conventions. Now, these empowering provisions do not say that you can only make direct reference to specific conventions. It provides a framework. If you think it is fit, you can make direct reference to these international agreements. Cap 369 and Cap 413 have the names of the conventions. Here we do not have. Now, the scope, in fact, is the same. The scope is the same as far as this provision is concerned. Cap 478 in comparison with 413 and Cap 369, and there are differences. 369 and 413 in the principal ordinance, in many provisions, have made reference to the international agreements or international conventions or protocols. This is unlike Cap 478. Cap 478 and doesn't mention, doesn't make reference to any provision of conventions or protocols. If we make reference to a particular convention here, that may not be appropriate. And there is no assumption that this ordinance has a direct provision mentioning a particular international convention. In the future, this ordinance may be related to other international conventions. Therefore, we will opt for a more general approach. Legal advisor. Well, I have nothing more to add. Just want to know whether other members have any views. I thank the legal advisor for pinpointing this one. I have asked them to be consistent. I therefore hope that the DFJ will give us a paper to answer this query. It is not just limited to this ordinance. Say, for example, the United Nations Security Council notices or announcements. They sanction one country against the sometimes here, sometimes there, and we have a model text. I think we need to deal with that. I think we need to be consistent. We shouldn't have different types or different styles dealing with similar things. Give us a paper and explain it in detail. Well, it's the same explanation. These three ordinances are different, and therefore the way of handling the provisions will be different, or are different. We'll give you a written reply to clarify this. Page 60, or 61 rather, Schedule 1A. We look at the persons not to be included. We may have to further amend it to clearly specify what is meant by seafarer. Page 62 of the English version, they are related and consequential amendments. Since the wording of the principal ordinance has changed, so other kinds of wording will have to be changed under the same kinds of wording have to be changed under the regulations or subsidiary legislation. Say, for example, seafarer, we no longer have registered seafarer. We only have seafarer whose name is entered in the register. 63, under subleg U, reference to seafarers changed by person. 64, subleg U5, section 5. We add an rank to clarify this. Section 6, subleg U, section 6, seafarer replaced by holder. That's similar to person. Page 65 of the English version. Amendments to section 11, reference to seafarer replaced by person. Section 12, same. Page 66, replace reference to seafarer with person. Please go on. Page 66, amendments to the schedule. As in previous sections, rating replaced by capacity and rank. And then seafarer replaced with person. And there are other textual amendments. Page 68. Subleg V, reference to seafarer replaced with person. Page 69, seafarer replaced with person. Page 70, non-registered seafarer replaced with seafarer whose name is not entered in the register. Now, there is no definition for registered seafarer, therefore we need to put down the meaning. Page 71, we cross out the definition of seafarer because under the Principal Ordinance Section 2A, we have provided the seafarer definition. We don't need to repeat it in page 71, nor do we need it in page 72. Page 73, the definition of seafarer cross out because it is in the Principal Ordinance. Page 73, we propose to change the schedule of the Administrative Appeals Board Ordinance. Certain references in the schedule are outdated. 57.1 has been amended, so this one will be crossed out. C, 52C will be crossed out, or is crossed out, and then we have added the amendments to clarify this. As for amendment to Schedule 1, page 75, company is replaced by body. Starting from page 97, that has been summarized in the bill. Do you want to look at the bill? We saw body, or rather, company replaced with body, and then seafarers with persons.
Page 74. Amendment to the section replacing seafarers with persons and then companies with bodies. 76, page 76. The same amendment to replace seafarer with persons and companies with bodies. Page 77, the same. Page 78 and 79, similar amendments to replace seafarers by persons and companies by bodies. Page 80, just the same. To replace companies with bodies and seafarers by persons. Pages 82 and 83, just the same. To replace companies by bodies and seafarers by persons. Pages 84 and 85, just the same. To replace seafarers by persons. Page 86 and page 87. To replace seafarers with persons. Page 88 and page 89, just the same. To replace seafarers by persons and companies by bodies. Pages 90 and 91, similar amendments. Pages 92 and 93, just the same. To replace seafarers by persons. Pages 94 and 5, the same amendments. Pages 96 and 97, to replace seafarer by person. And ends the marked up copy. Mr. Ho. It would like to move an amendment to replace all shells with musts. Will the administration ensure that there are enough votes to veto our amendment? Well, policy-wise, there is nothing against this because they only involve textual amendments, and explained by our lawyer. The legislation is rather old, and she's explained why the technical amendments are not dealt with this time. Now, the question is, we don't have a lot of resources and manpower, although this is a very worthwhile exercise. Now, if the administration is of the view that this is against your policy, then of course we ensure that you have enough votes to veto our CSAs. Well, then why don't you do it? Instead, since you have more resources and manpower, why don't you take this opportunity to do it, to tidy up the legislation? We haven't said no. All right, I have the word from the administration. So will the administration move the CSAs? If necessary, we will move the CSAs. It is needed now. There is the necessity now. After your amendments, there will be two different presentations causing confusion to layman readers. I fully appreciate or understand Mr. Ho's view, but we will have to ask our lawyer to vet the provisions very carefully. And if we have any proposed CSAs, we will show the draft to members to see if they are acceptable to members. So for the queries raised at this meeting, will there be a paper from the administration to address the concerns such as the definition of seafarer, because we've ended the clause-by-clause scrutiny? Is it necessary to meet one more time, or should we wait for the administration's reply first? And if there is any member who is not happy with the reply, then we can call another meeting. Yes, we will provide a written response to all the queries raised at this meeting, including definition of seafarer. If we have any proposed CSAs, we will submit the draft for members' consideration as well. Chairman, I feel very strongly about this. I want the amendments to avoid confusion caused to layman readers. I believe the administration should take this opportunity to unify the wording here, to replace shall with must in all provisions. Because if we do it on the behalf, then it will be a shame for the administration. You would look rather ugly, lazy. Yes, this is not really a big deal. Can the administration think of a simple way of doing it? If you move it, then there is no need to go for split voting. And if you're not willing to do it, and if we take the initiative, then it would reflect rather badly on the administration. We haven't said no. Thank you, Chairman. Allow me to explain once again. I thank Ms. Ho for her support for our policy to modernize our laws. We're grateful to members for your support. Why have we chosen not to replace all the shells in this exercise? Because the focus is really to implement the convention. Cap 478 was enacted in 1995 with more than 100 provisions. We did consider whether we should align all the words, shells and musts in this exercise. Then the bill would not be 200 pages as it is now. It may be threefold this size. So we decided to focus on provisions related to the convention only, because only 20% of We don't want the bill to have amendments that are substantive. We don't want the textual amendments to take up 80% of the bill, because that may affect the scrutiny of the bill. So we decided to make the corresponding amendments if they are related to our substantive amendments. As the legal advisor said, we have a guideline for law drafting. Of course, we've decided that must should be used instead of shall in the future. And when we prepare an amendment bill, there are bound to be this scenario. Old provisions will contain the word shall, whereas new provisions would contain the word must. There are bound to be such inconsistencies. But it was decided back then that if the quantity of work is too much, then the direction we got was, now, if in the same section the old and new forms coexist, that is acceptable, because we decided to do it in the most efficient manner. So we'll have adhered to the guideline in the current handling. Ms. Ho asked whether we can take this opportunity to move CSAs to replace all the shells here. We have to discuss with our law drafting division, because we may have hundreds of pages of CSAs if we are to do that. Of course, we understand that the members would like us to modernize our laws as soon as possible. We'll discuss with the Bureau. And some colleagues are dealing with similar issues. Well, in this amendment bill, we have the old and new forms coexisting. Now we have a revision order in the pipeline to deal with all technical matters by means of a schedule. For instance, the old-fashioned words will be modernized, but there is another way of handling. And there are many similar amendment bills are facing the same situation. And I dare not say how long the queue is. Ms. Ho. Well, for those who have studied secondary, primary school, we all understand what shall means. I think if many people can understand the meaning of shall. So this is not my main concern. My main concern is if shall and must appear in the same subsection that may cause confusion. If you say that the bill will be too voluminous, I find it unacceptable. The DOJ may rather not replace the word shall this time to avoid confusion, because we all understand the meaning of shall. In the same legislation, it's really not good that the old and new forms coexist, but we do understand modernization and law adaptation takes time. But if we have only one amendment bill here and you choose not to do it, then I'd rather you leave the 20% you're going to amend altogether. Legal advisor, any comment? Members may be aware that when shall appears in a certain section, after considering in context, the word shall may not necessarily be replaced by must. I'm sure we have seen such cases, and I think the law of draftsmen would know better than we. Ms. Zhang, who I said we'll discuss with the Bureau once again. However, I'd like to make a response. If in an ordinance there are both old and new forms, of course, that's not the most desirable. But we have many pieces of legislation in this situation. There is a real practical difficulty if we want to handle or to change everything in one go. I think we have explained at the AGLS panel that it's not easy. When we come across any, we will amend the text. We will try our best, but of course our members have a different point of view. I will discuss with the DOJ Law Drafting Division once again. Yes, I understand that sometimes we cannot amend the words in a mechanical manner. So please do not change some and leave some, otherwise you will certainly cause confusion. I understand that if you want to deal with the whole ordinance, then you have to go through the provisions one by one. Then rather you don't change the words at all. You leave the 20% behind so that it will be easier. It's true, if you just change some of the provisions and not all, this will cause confusion. And I'm afraid that this will become a precedent. We are worried that if you're lazy this time, next time you will quote it as a precedent. Can we have a better precedent who will extend the meeting for no more than 15 minutes? Will the administration consider Ms. Sitho's view?
Chairman, I think the DOJ representative is not able to answer me today. They can go back and discuss it. I've already said what I want to say. Either you do it completely or you don't do it at all. This is to avoid queries. People will question why is here shall and why is there must. Are there any difference? So we'll go back and consult the Bureau and then discuss among yourselves and then give us a reply together with the questions we have raised today. And then members, having received your reply, will consider whether there is a need to have another meeting. And then if you want a meeting, you can talk to me and the Secretary. If you don't ask for another meeting, then we may not call a meet again. Okay? Any other questions? If not, then meeting adjourned. Thank you very much.